Good afternoon, everyone. My name is Richard Blake. I am co-chair of McDonnell Hopkins White Collar Government Compliance Practice. I want to welcome you all here to our Cleveland office, as well as everyone on the line. I think we have a good number of people who are listening in over the webcast. And the business advocate is what we have out there, and we ask everyone to review it. Look at it, there's a lot of excellent articles on there and topics that we try to give to the public on there, so we highly recommend it. Our topic today is an ounce of prevention, avoiding federal investigation, litigation, and business disruption. We've planned what we hope is an interesting and informative discussion today. I'll be brief here at first because we have a considerable amount of information. I've seen Ms. Armstrong's and Mr. Reinhardt's work, and they have very informative, a lot to go through. Bruce Reinhardt is a co-chair with myself of the White Collar Unit here at McDonnell Hopkins. He operates out of our West Palm offices. Next time we will try to have this meeting down in our West Palm offices, and you're all invited. And Jennifer Armstrong next to me, an associate in our firm in the White Collar Unit and as well. First, I want to invite everybody during our talk here, feel free to ask questions in the audience here in Cleveland. Please, if we're talking about something, don't feel that you need to wait until the end to ask. So you can ask. Well, we will repeat the questions for the folks online, and people who are listening online, feel free to tweet your questions in, and we'll answer it throughout. So again, we don't have to wait until the end if you don't want to. If I'm missing anything here. Missing anything, Jen? First, we're going to have Bruce Reinhardt talk about the False Claims Act. This is a statute I figure that the far majority of us have heard of. Some people say it's somewhat familiar with it, but they don't know the intricacies of it. And Bruce, he'll tell you his background, has extensive background with the Department of Justice, with both in Washington and with the U.S. Attorney's Office down in Florida. Worked with the False Claims Act extensively. Prior to giving it over to Bruce, I'll give you the quick background on it, because a lot of people don't fully understand how the statute came about to where we are today in 2014. It's a statute, its nickname at the time was Lincoln's Law, as in Abraham Lincoln. It was written by Congress during the Civil War. If you think Congress is troublesome now with problems, read historical documents as to what the Congress in the 1860s was, what in the 1850s was. It was I think the legal term would be a mess. They had these situations, and I've researched this, having been hired by Janet Reno originally to work just False Claims Acts at the time. There were situations where during the war, the Civil War, it was the Department of Defense, it was the Army, and actually they didn't call it the Department of Defense. The Union Army contracted with folks in the North for such thing as clothing, gunpowder, other goods for the Army. And in fact, what started happening, instead of stitching the uniforms, they were gluing the uniforms. They'd fall apart during the rain. Instead of having caskets of gunpowder, they were given flour. This is all documented at the time. So it was so bad that there was such corruption on the part of the private contractors to the government at that time. They passed this law, which said basically anyone who makes a claim to the government that's fraudulent, you say that you're selling us gunpowder, you're giving us flour, you now owe us double the amount that you were paid. Through the years, particularly in 1986, they've taken this law to make it triple damages. And as you know, you probably heard these stories with the Department of Defense during the 70s and 80s with the $1,000 toilet and the hammers, for all this expensive costs. If a company, particularly in the Department of Defense, and now in the healthcare world, submits a claim to the federal government, in healthcare it would be with Medicare and Medicaid, since a portion of the Medicaid funding is federal, and it's deemed to be fraudulent, and again, that's where it gets murky, and that's where the arguments come in. But if it's ultimately found to be a fraudulent claim, the person making the claim is liable for up to 3 times the amount that was paid. Some people will argue the amount billed, and you know that though you bill a certain amount of money, you only get a portion of it back. Those are arguments that we have with the government many times. Needless to say, it's still a heck of a lot of money. And in addition to triple damages, it could be anywhere up to about $11,000 or so per claim. another argument there. If you look at the billing pages of providers that submit their daily billings, you'll have hundreds to thousands per day. And there will be people who will argue it's 5,000 to 11,000 for each of those billings. The courts have ruled against that, but it's still a significant amount of money. So you'll see some of these settlements with these companies, $100 million. We'll talk about a little bit. Well, I'll touch on some of these because some of them are local. Here, Cincinnati, $108 million, hundreds of millions of dollars with the big drug companies, billion-dollar settlements. So this is large money, but they're not just all these big cases. Many, and in fact, I think most of the cases are smaller cases. So when we hear about these large settlements with big drug companies, we think, well, that's not us. We're under the radar. I assure you, and Bruce will talk about it, the government's getting bigger, you may have heard, and they're hiring more people to follow up on these types of cases. And that's why we feel it's important that everyone have a general understanding of how these work.
Thank you, Richard.
Bruce?
Thank you. I think some advocates today of the False Claims Act would argue that not much has changed since the 1860s, that there's still a large population out there of vendors who are trying to steal from the government. And a lot of the challenge that we face in representing those sorts of companies is making the government understand that sometimes mistakes are made, sometimes mistakes aren't made, but not everyone is out to rip off the government. And so we're going to try to talk today about some of those issues, how they come up, how you and your clients and your companies can protect yourselves from getting caught up in this web. But it is definitely dangerous times out there for anybody doing business with or filing claims with the government. So let me talk first about just the nuts and bolts of how the False Claims Act works. And then I'm going to talk a little bit about some scenarios that we see commonly arising in this area. What's unique about the False Claims Act is it is a enforcement action on behalf of the government, but it's brought by a private individual. So a private individual who is legally called the relator, who is commonly referred to as the whistleblower, comes forward and actually files a lawsuit in federal district court against you, your client, someone like that, against a government vendor on behalf of the United States. So the case will be called, John Smith on behalf of the United States against ABC Corporation. So that suit is filed publicly. In order to be the relator, it's filed in the court record. It's not filed publicly. It's filed under seal, so it remains secret. Along with that complaint filing, the relator has to submit a memorandum and other evidence in support of their claim directly to the Justice Department. And the relator has to be the original source of that information, so they can't just read it in the newspaper. So generally speaking, who's going to have original source type information and who's going to be the population that becomes a relator? It's generally disgruntled, either current or former employees. I see people nodding their heads up and down. Disgruntled former business partners and industry competitors. People who feel like, I'm not getting a fair shake in the marketplace because the fellow down the street is cheating the government, so I'm going to try to make a profit for myself. I'm going to report them to the government and recoup some of the money. So the relator files the suit. It's filed, as I said, under seal, so it's secret. So you and your company could be under investigation and not even know about it for some period of time. And although the original seal is only for 6 months, they're commonly extended. We've had cases where cases have remained under seal for 2 to 3 years at a time. So the case is filed, it remains under seal, and that's intended to give the government time to investigate. And during that time period, the government is having a lot of dialogue with the relator. So this person who by definition is hostile to you is now in the government's ear and is feeding the government a lot of information, not necessarily truthful information, but feeding them information, telling them who to go talk to, telling them what documents to go look for. So the government is getting a very one-sided view of the case. But that right there is what makes the False Claims Act unique and what makes it a particularly risky area, because it's not enforcement driven by the government, it's enforcement driven by a private individual who has a profit motive. What's their profit motive? The relator shares in any recovery by the government. Generally speaking, the relator can get anywhere from 15 to 25% of what the government recovers. So when you read in the paper that, for example, the Princeton Review in New York settled a case for $10 million, well, the relator got $1.5 million out of that, or $2 million, something in that range. And equally motivating people is that the lawyer's fees get paid on top of the recovery. So you have lawyers out there who are driving these cases in many respects because the attorney's fees can often exceed what the relator's share is going to be. And what we have seen, and one of the dangerous trends we have seen, is lawyers who used to do securities class actions, medical malpractice, and personal injury, where that part of the sector has dried up, those cases have gotten harder and harder to make, have realized, hey, I can just take that same skill set over to the False Claims Act and bring these kind of cases and get even bigger recoveries. So in the Department of Justice just reported that in 2013, they had a record number of False Claims Act, or they're also called quitam cases filed. There were 752 cases filed in calendar year 2013. That was 100 more than in any other year in history. And from everything that we're seeing, that trend is going to continue upward, because every plaintiff's lawyer in America thinks they're going to get rich on a quitam case. And they're out recruiting for it, they're out advertising for it, and that's causing big problems for people in the industry because there's just more people focusing on you and shooting at you. In addition, last year, the Department of Justice recovered $3.8 billion in these cases, and the relators shared $345 million of that. So it is a lucrative area for these kind of people. So that's why we think we're going to see a continued growth in this area. But, so the case is filed, it's under seal, the government's investigating it, you don't know anything about it. There will probably come a point when you're going to find out about it one way or the other. You're either going to find out about it because the government contacts you. Because at some point, even though the case is filed in the name of the government is not technically in charge of the case. There comes a point at which the government has to make a decision to, and the legal term is intervene in the case, and decide whether they're going to take over or not. If the government intervenes, the government takes over the prosecution of the case, and the relator gets a smaller recovery. If the government says, we just don't agree, we don't think this is a good case, we're not going to intervene in this case, the relator can still proceed. So it's not like a typical government enforcement action where if Richard or Jennifer or I go in and we meet with the assistant U.S. attorney or the Department of Justice or the law enforcement agency and we convince them not to bring the case, that it's not in the public interest, the case goes away. Well, in the False Claims Act area, it doesn't. The relator retains the right to pursue the case on their own if they want to. Now, it used to be that was the big fight, was getting the government not to intervene, persuading the government this was not a case worth going after. And if you persuaded the government not to come in, the cases went away because relators like to go after defendants who have lots of money. And the theory on the relator side was, well, they have a lot of money, that's good, I can recover from them if the government will do the work for me. On the other hand, if I have to litigate against them and finance it myself, they have a lot of money and they'll spend me into the dirt, so I'm not going to pursue the case. That dynamic has changed in the last year or two, because what's happened is a lot of these relator side law firms have done well. So they have money now and they are prepared to finance the litigation, just like in the medical mal cases, just like in some of the class action cases, where the lawyers will actually front the money to advance the litigation because they know at the end of it, if they get $1 in recovery, they get all of their fees paid for. So they are effectively litigating against the defendant with the defendant's money, because they know that at some point it gets exorbitantly expensive to defend. And if you're looking at even if it's a frivolous or meritless claim, and it's still going to cost you a couple of $100,000 to defend it, it's cheaper to just pay something to settle it. Well, in this genre, when you pay something to settle it, you've got to pay all the attorney's fees. So again, cases that used to fall off and go away if we convince the government not to intervene are remaining alive, and they're creating problems. So that's more aggressive enforcement. So at that point, either the government intervenes or they don't intervene, and either way, if somebody continues on with the litigation, it's civil litigation. You defend against it. You try to explain why the case isn't meritorious or why it shouldn't go forward. So that's sort of the nuts and bolts of how it works and why nowadays that threat is growing given the private sector involvement in the regulatory enforcement. What do typical cases look like? Where do they typically come from? Most of the big cases you hear about, as Richard mentioned, are in the healthcare area. Big pharma, for whatever reason, the pharmaceutical companies have been an easy target lately. But it's not just big pharma, and it's not just healthcare. Just in the last year, there was a major recovery against United Technologies for $475 million down in Cincinnati for defense contracting false claims. There was a recovery, as I mentioned, against the Princeton Review, an educational company, but they were getting grants and loans and financing through the Department of Education, so they were subject to a false claims case that was settled. There have been a number of environmental cases, doing environmental cleanup for the government or doing other certifications to the government for government work. There are other cases in the procurement field. There's one that was settled out of, I forget which district, involving a software vendor. So just if you're not in the healthcare space, you can still be susceptible to this. And another case that we're personally involved in right now is a small business administration, women-owned business case, where it is alleged that a company falsely claimed to be a woman-owned minority business in order to get preferential government contracting. They were a subcontractor to a major multinational billion-dollar construction company that got the contract, and somebody brought a qui tam action against the major construction company and the subcontractor and our particular client in the case, who was the lawyer who was advising the woman-owned business that they could apply for this on the theory that he knew what was going on and participated in it anyway. So even though he didn't make any direct claims to the government and he didn't participate in any direct interactions with the government, he's been dragged into it. So aggressive and creative plaintiffs' lawyers can find ways to bring people in. So there's a lot of risk out there in a lot of different sectors. If in essence, if you are doing business with the government, you have risks. Because even if you're not necessarily in a direct government procurement vendor relationship, you could be filing certifications with the government to get funds paid to you or as part of contracting or bidding. And those certifications, no doubt, you're saying we're complying with all the federal acquisition regulations, we're complying with all applicable federal regulatory regimes. Well, that can be a false claim. If that's falsified and you get some money for it, now you're looking at a false claim. So, as I said when I started, it's dangerous times out there. There's a lot of risk in the marketplace. And so we try to be very careful in staying ahead of these things. At this point, I'm going to hand it off to Jennifer. Jennifer is going to talk a little bit about the Foreign Corrupt Practices Act, which deals more with foreign governments and not our government. And then I think we're going to circle back, and Richard's going to talk about some of the best practices in the False Claims Act space.
Well, international markets present huge opportunities, but they're fraught with compliance issues for the unwary. So I'd like to speak today a little bit about the Foreign Corrupt Practices Act, or the FCPA, which is a hot issue for companies that do business internationally. First, I'll talk to you about why you should care about the FCPA, with a particular focus on some recent enforcement actions. Second, I'll give you a very brief overview of the FCPA provisions to provide some context for our discussion. Third, I'll discuss some red flags of corruption that you should watch for, especially with third-party intermediaries. And then finally, I'll review some practical compliance tips that your company can take to hopefully avoid running afoul of the FCPA. So why should you care about the FCPA? Basically, you should care about the FCPA because it's a very hot issue right now for DOJ and SEC. Violations of the FCPA by a company can lead to civil penalties, criminal penalties, sanctions, including fines, disgorgement, and implementation of a corporate monitor, somebody that's in your business and is looking at your business. It's also important to note that individuals also have liability for FCPA violations. The penalties can include up to 5 years in prison, $10,000 per violation, or both. The FCPA has become a revenue-generating statute for the federal government, which is another reason why it's growing. In 2013, the government collected over $720 million from FCA enforcement actions, which was a marked increase from the $260 million collected in 2012 and the $503 million collected in 2011. So companies that have been ensnared in FCPA investigations and have paid millions since 2013 include Diebold, a local company. They paid a $48 million settlement for improper travel and entertainment expenses by one of their subsidiaries, and they were also hit with a corporate monitor. Avon had to pay $132 million in a settlement for, again, improper travel, entertainment, and other expenses. Hewlett-Packard, $108 million settlement for payment by subsidiaries in 3 countries to government officials to obtain or retain contracts. ADM paid $17 million to settle allegations of bribes through third-party vendors to Ukrainian government officials to obtain VAT tax refunds. So in addition to the millions of dollars in fines that these companies had to pay, they incurred significant legal fees. For example, Avon reported that it had paid over $300 million in legal professional fees since 2009 relating to its FCPA investigation. Remember, they only paid $132 million in their settlement, so that was 3 times more in legal fees. Companies such as Avon have also been hit with shareholder derivative suits stemming from the FCPA violations, so you have these parallel cases going on. And companies have also experienced reputational damages. I'm sure you've heard about Walmart's issues in Mexico, which is harder to quantify, but it's nonetheless very significant in the marketplace. So I want to emphasize at the outset, though, this is the positive part of the message, that your company's investment in implementing or reinforcing a robust FCPA compliance program can result in enormous cost saved. For example, recently both the DOJ and the SEC elected not to charge Morgan Stanley with FCPA violations, even though they criminally prosecuted one of its managing directors for the same conduct. So in doing so, the DOJ and the SEC cited the company's very effective compliance program as the primary basis for their decision. The SEC and the DOJ have for some time been broadcasting the message that self-disclosure, cooperation, and investment in compliance count. And the Morgan Stanley case really shows that they're putting their money where their mouth is. So to provide some context, I'll briefly review the relevant provisions of the FCPA. It consists of 2 parts. The first is an accounting provision, which requires companies to keep detailed books and records of all payments made. And it also requires companies to institute internal accounting control systems that assure management control over the company's assets. We're not going to really talk about this section today. What we are going to focus on, though, is the second provision of the FCPA that gets the most attention. So it prohibits companies and individuals from corruptly offering, promising, or giving anything of value, in quotes, to a foreign official, again in quotes, for the purpose of influencing official acts in order to assist the company or the individual in obtaining or retaining business or to secure any proper advantage. Okay, so what does that mean? The term foreign official is extremely broad, and it's defined to include officials of a foreign government, a public international organization, a foreign political party, or any agent or any intermediary. So it applies to officers and even low-level employees of government-owned corporations. Many doctors and professors of foreign companies would also be included here because education and healthcare in many companies are government-run. So essentially, if you have any doubts about whether a person is a foreign official, you should assume that they are. Obtaining or retaining business, again, very broadly defined. Examples would include winning a contract, circumventing the rules for importation of products, evading taxes or penalties, avoiding contract termination, or influencing lawsuits or enforcement actions. Anything of value, again, very broad. Examples would include cash in the guise of consulting fees or commission, travel, entertainment expenses, and gifts. There must be a corrupt intention to violate the FCPA. So the offer, payment, or gift must be intended to induce the recipient to misuse his official position to the payer's benefit. Importantly, it doesn't require a recipient to actually misuse his official power. An attempt to influence him is enough. So if you have an executive who authorizes others in his companies to pay whoever you need to, and a foreign government to obtain a contract has violated the FCPA, even if no bribe was ultimately offered or paid. So I'd like to talk a little bit about the common problem areas or red flags that we see. The DOJ recently issued a resource guide to the FCPA. It's about 130 pages. A lot of it's fairly high level, and examples are sometimes not especially helpful because they don't really help you in the gray area. For example, they list things like lavish travel and entertainment expenses. There was a company in California who spent approximately $7 million between 2002 and 2007 on 225 trips for its customers. They paid for Chinese employees to travel to popular US spots under the guise of training, but there wasn't actually any training provided. I don't really think that you probably need to read the FCPA resource guide to understand that that would be a problem. Lavish gifts, again, to a foreign official would also be impermissible, but also a foreign official's family. In one case, the defendant paid personal bills and provided airline tickets to a cousin and close friend of the foreign official whose influence the defendant sought in obtaining contract. The most common mechanism for FCPA violations is the use of intermediaries. And because this is a more complicated issue and harder to spot than travel and entertainment gifts and expenses, I'd like to just spend a little bit of time on that. In FCPA jargon, an intermediary is a third person who assists the company in some aspect of its foreign business. Very common. In a recent survey of general counsels, only 43% of companies regularly conduct due diligence on these intermediaries. And it's important to understand that these intermediaries don't shield your company from liability, they create liability. 90% of the FCPA cases brought by the US government involve conduct by third parties. And in most cases, employees of the US company knew that their foreign intermediaries were involved in illegal payments and sometimes directed them to do it. So I'd like to just walk through some common red flags that you should be aware of when your company is doing business with third parties. First, I would describe a category called reputational red flags. This would, some of this is common sense, but still important to know. I mean, if you're dealing with a third party that's been subject to criminal enforcement actions or civil actions, that's a red flag. It's also a red flag if the third party doesn't have an adequate compliance program or a code of conduct, or if other companies have terminated this third party for improper conduct, or if information provided about the third party is not verifiable by data, only anecdotally. Another kind of red flag category would be government relationships. If the third party has a family relationship with a foreign official or a government agency, or a business relationship, or they've previously worked with the government at a high level, this can be a red flag. It's also a red flag if the third party is a company and is a majority shareholder of a company, or the rumor that this third party has an undisclosed beneficial ownership in a company. Also, if the third party makes large or frequent political contributions, charitable contributions, if they have private meetings with government officials, or if they insist on dealing with government officials without the participation of the company, these are all red flags. Another kind of category of red flags would include the type and method of compensation that the third party uses. If the third party requests an unusual advance payment, or their compensation arrangement is based on a success fee or a bonus, or they offer to submit or they submit inflated, inaccurate, or suspicious invoices, all red flags. It's a red flag if a third party requests an invoice to reflect a higher amount than the actual price of goods provided. It's a red flag if the third party requests that payment not be made to them, but to another third party or intermediary. If they propose the use of shell companies, if they request that payments are made to 2 or more accounts, if they share compensation with people whose identity they don't disclose, all of these are red flags. If they refuse to properly document expenses, or they're constantly pressuring the company to make payments urgently or ahead of schedule, these are all red flags. Finally, red flags with third-party intermediaries would include any unusual circumstances, obviously a very broad category. But some examples would be they refuse to execute a written contract. They insist that their identity remain confidential. They refuse to divulge the identity of its owners, directors, or other principals. They suggest that, this is just the way we do things in this country and don't worry about it, it'll be fine. That's a problem. So I think I've given you hopefully some tips with third-party intermediaries, and now I'd like to kind of walk through some areas now that we've gone through what the FCPA prohibits, some red flags of corruptions, some kind of concrete things that you and your company can do. to prevent running afoul of the FCPA. First and foremost, you need to understand your company's risks. You need to remember that a government official is extremely broad and, again, includes even low-level employees of government-owned companies. It's important to understand every way in which your business has contact with government customers or employees. If you don't understand your company's specific risks, you'll fail to allocate your compliance resources in a cost-effective manner. So for most companies, 80% of the FCPA risk will come from less than 20% of your business. So if you don't understand the risk, you're not going to be spending the money accurately. So how, you might ask, do you assess your risk? You could do it in a number of ways. First, you have to understand what kind of business your company does outside the US. Where do you do business? If you're doing business in China, Brazil, India, or Mexico, these are companies that are well-known corruption risks. So are Russia, Vietnam, Nigeria, and Pakistan. Do you conduct foreign business through your own employees, through agents, distributors, and intermediaries, or through joint venturers? Do you ship through freight forwarders? Do you use custom agents? Do you deal with universities and professors and doctors? As we've discussed before, all of these people can be government employees for purposes of the FCPA. You can also use local hires to educate the company on how local laws are typically circumvented so that your company can institute controls to prevent it from happening to them. Another tip, second, you should have a standalone anti-corruption policy. Don't just rely on a few paragraphs that's buried in your standards of business conduct. It's not enough. And you also don't want this to be a cookie-cutter policy. The DOJ has said, again going back to the resource guide, that each compliance program should be tailored to an organization's specific needs, risks, and challenges. Third, you should designate a member of your company's senior management team to be responsible for FCPA compliance and accountable for the program. Tone starts at the top, so your board, CEO, and CFO need to communicate to their employees that they are committed to FCPA compliance. Fourth, train your managers and employees with the actual corruption risks in your industry, the companies where you do business, and the business model your company is using. Online training is better than no training at all, but skilled in-person training is superior, and a mixture of the two appears to be the best practice now. I would say, however, that in-person training for your board and senior management is recommended. Fifth, design hotlines that internal whistleblowers can use to report suspected violations and impress upon employees that their identity will be kept confidential and that there will be no retaliation. And whenever possible, try to follow up with employees after the investigation to determine that the whistleblower reports were taken seriously. Sixth, train the third parties who facilitate international distribution and conduct due diligence, because as we've discussed, they're the ones that represent the highest FCPA risk. Some small companies think they're safe if they use third parties who also represent US multinational companies. They're assuming that large companies have done proper training and vetting, but that frequently is wishful thinking. Major US and multinational companies often have weak FCPA compliance programs, and they don't train or vet the third parties. So don't kind of kick it up to the large company and assume they're doing that kind of work. Seventh, include clear FCPA terms in every international contract. This is very inexpensive, and it reinforces the message that your company won't tolerate corruption. Your contract should specifically mention the importance of FCPA compliance, and you should also require your partners to represent that they understand the FCPA and follow it. You should have a clearly worded audit clause that requires the business partner to provide documents and assistance in the event of any investigation. And finally, you must have the ability to terminate the contract if your business partner violates the FCPA, because you don't want that coming back on you. So, kind of closing remarks, I'd like to remind you that our team can assist you in evaluating your FCPA risks and drafting and helping you implement an FCPA program. In the case of Morgan Stanley, the company that I talked about at the beginning that was not prosecuted for FCPA violations, even though one of its employees was, an effective compliance program saved them millions of dollars in fines, business disruption, and reputational damages. And we can help you do that. So just pick up the phone and give us a call if you have any questions.
We have a couple of questions, and let me ask Jen first. Can you discuss the, the liability of a U.S. corporation for the actions of its foreign subsidiaries under the FCPA?
Well, and actually, there is liability, and in the cases that I talked about, for example, Hewlett-Packard, it was through an HP subsidiary. It doesn't matter. You're on the hook for it if one of your foreign subs does the contact. And in fact, that's the most common, is a U.S. company through one of its subsidiaries performs an action, and that's how they get hit with the FCPA violation.
Richard, if I could. I think what Jennifer's saying in the FCPA area is also true in the False Claims Act area. It is the person low down in the food chain, far away from the centralized control of management, who is your biggest risk factor. And it's generally the person who has the greatest motivation to make the deal go through. So it's your sales force. Half or more of the cases you see involving government contracting, it's the person dealing directly with the contracting officer. It's the person who's going to get the sales commission for the deal going through. Or in the FCPA case, it's your foreign agent in that country who only gets paid if you get the deal. That's where your greatest risk is, and unfortunately, they tend to be far away and out of sight, out of mind a lot of times. And that's the real challenge in your compliance policy. And I'd echo one other thing Jennifer said in that regard. To the extent you can, whether it's in 1099 agreements, employee handbooks, or other contracting documents with your own agents and your own affiliates, have language in there where they're warrantying back to you that they're not breaking the law, that they're aware of what the rules are, that they've got their own compliance programs. Protect yourself. At the end of the day, and I think Richard's going to talk about this in a moment, no compliance program is ever perfect. No one can ever design you a 100% perfect compliance program, because people are human and mistakes will happen, or you'll get the rogue employee, or you'll get someone out on the margin who just doesn't buy into it. And when that happens, as it inevitably does, the optics become very important. And the optics are, you had a compliance program, you did everything you could in good faith to prevent it from happening. And in our experience, that's what you can sell to the government. Look, maybe we had a screw up, maybe we had a rogue employee, but we did everything in good faith that our company could reasonably be expected to do to try to prevent this. So yeah, maybe we're worthy of a little bit of a tap on the wrist, but not a big smack. So I'm sorry.
Oh, no, please. The answer that you gave about the foreign subsidiary kind of, I think, flows in well with another question that we had, and I apologize because of my ability to read it. But I think, in essence, and the person who wrote the question, if I'm not asking it correctly, raise your hand, please. You're liable for your foreign subsidiaries. You're looking at it from a business person standpoint, doing business overseas. Big world out there. Not every place is England. I mean, you've got different parts of the country where cultures are completely different from ours and the people who make the rules here. Doesn't the FCPA sort of limit U.S. companies' ability to compete effectively with other international companies out there? And there was a reference here in the question to OPEC countries in general. Does it unfairly hinder the U.S. companies' ability to compete?
I think that's a good question. The FCPA came into being in 1977, but now you have the UK Bribery Act, you have China aggressively going after, for example, GlaxoSmithKline. A lot of other companies are also jumping on the anti-corruption bandwagon. So I would say that this is almost creating more of a level playing field than there may have been 10 years ago. And there's also now more enforcement actions that companies need to be worried about. It's not just the US.
Right, and part of the problem there too, Jen mentions the UK Bribery Act, Mexico has one, Canada has one. Some of the rules in those statutes are actually more stringent than the FCPA.
Like the UK Bribery Act.
Right, the UK Bribery Act is broader. So there's conduct that is lawful under the FCPA that is not lawful under the UK Bribery Act. So you have to be very careful in that regard. So far, the UK hasn't been aggressive in their enforcement, but let's be honest, a lot of these countries see the amount of revenue that the US government is generating from these actions, and they see this as a revenue source. Yes, sir?
I asked the question, but also like the main countries, Mexico, India, Indonesia, Nigeria, and Turkey, those countries are growing bigger than the BRICS. And the BRIC countries, a lot of them don't have these acts, and they're growing faster. U.S. So I think I was expressing my opinion that China they have law, but a lot of times they don't enforce it that much unless it's against countries that want to enforce it. They're very picky. So U.S. companies are fairly hampered in the global market because, like in Nigeria, when I grew up in Nigeria, oil country, you have to bribe.
Right.
Look at the contract. It's just about like, you have to bribe.
Right.
So companies hire consultants to do it.
And we want to just say, for the purposes of the folks who are listening, we want to restate what the speaker stated. Born and raised in Nigeria, his comment was that countries such as England are not the powerhouse that they used to be, and that the powerful new countries that are making waves out there are Nigeria, China, other smaller and African countries. Turkey, I think you said, some of the yeah, these countries have no FCPA. So these are the countries that we are competing against right now, and it's an unfair competitive advantage that those countries have. So we're fine with England, but when it comes to the countries who are actually quadrupling their gross national product on a monthly basis, it's not fair. Would that be a fair statement?
I would again go back to, I recognize that there are some countries that don't have it, but with so many other countries having the creation and the enforcement of more laws. I mean, GlaxoSmithKline, they fired, I think it was something like 300 doctors recently in China. The US companies are probably competing with other US or EU companies, and all of those countries would have a mechanism. And I guess I would also say too that while corruption may be a fact of life, it's not something that we want, and that's what these laws are supposed to prevent.
Yeah, there are all kinds of U.S. laws that create competitive disadvantage. Some of our environmental standards, our labor laws, and other things are well above what the standards are elsewhere in the world. And that's certainly a political policy discussion that can be robustly had with the right people. What we're here to tell you is we all collectively have to live with the laws that we have. And the laws that we have create tremendous burdens and risks for business. There are ways to manage that risk. There are cost-effective ways to manage that risk, and that's what we're here to help you with. But whether it's a good or bad idea, we can debate that, but it is what it is, and we're stuck with it.
And that's what we deal with regularly, I would say irregularly, but somewhat regularly with clients who don't like the idea of having to compete unfairly. And our job is to be as creative as possible within the parameters of the law. So we as a good lawyer out there, will work their best with a client, but yeah, if you're going to do business here, you have to comply with the laws here.
But it's also both in the Foreign Corrupt Practices Act and the False Claims Act area. The whole theory of enforcement is one of deterrence, which means the government can't possibly prosecute or enforce the law against every single person who pays a bribe in China or Nigeria, or every single doctor who's taking a kickback, or every pharmacist who's upcoding. So their theory is we have to deter that conduct by having meaningful penalties against the people that we catch, which is all the more reason why you don't want to be the one who's caught in their bullseye, because not only are you going to get punished for what you did, you're going to get punished to send a message to everybody else. So the punishment in many respects is disproportionate to what you did, but that's what the government's going to demand because they want to send that message. And so a lot of compliance, a lot of what the three of us do is keeping you as far from the center of the bullseye as we can. We can't ever promise you won't be on the dartboard, but we can keep you as far to the side as we can.
Bruce, I believe that there was a question about the False Claims Act.
There was a question about outside the False Claims Act, there are other whistleblower provisions under federal law. The big one that's gotten a lot of attention in the last year or two were the whistleblower provisions of the Dodd-Frank Act relating to securities and the securities industry. That's really such a new area that the law and the policies and the procedures are just now starting to develop. The SEC, I know, issued some final regulations within the last year. I think the first wave of whistleblower complaints have come in. I can't tell you as I sit here today that there's a lot of clarity we can give you. If you happen to be in that industry where you're dealing with securities or securities FINRA type issues, or if you have someone who's lost a significant amount of money and feels like they have a whistleblower claim, we can certainly work with you on a one-on-one. But in candor right now, there really aren't any broad trends to point to, other than I know under the Dodd-Frank provisions, there are some requirements that in addition to being the original source of the information and getting to the government, you may have, if you work for one of these companies, if you work for a regulated company, you may have had an obligation to report it internally first before you can then bring action outside. The False Claims Act does not require that. So the whistleblower in the False Claims Act non-securities setting can run directly to the government. In the Dodd-Frank situation, in many situations, they cannot.
And I think the way that, because Richard and I actually have, I think, some experience in representing a whistleblower for the in front of the SEC for the
unnamed
yes
party.
for an FCPA. So we did some research into it. A lot of times it's first to get to the SEC, and so the way that I recall the law is written is if you report to your company first, then if you subsequently report to the SEC, then it takes the reporting date to your company and makes that the reporting date to the SEC. And I think there's only been one recovery announced so far. It was pretty minor, 200,000 or so, but it's 10 to 15% of what the government recovers.
And according to the folks at the SEC, there are other cases in the pipeline, which we do not know about unless you're involved in it. And that's another deal when you're situation when you're dealing with the government, particularly the federal government. Their standard answer is, and it has to be, we can't talk about it. So we really don't know how many cases are going through the SEC's offices. They've got a huge building in Washington. They got a lot of room there to do a lot of cases, and I would bet safe money in the fact that there are plenty being looked at and investigated by those lawyers, as with the Department of Justice with the False Claims Act.
Yeah, Richard, I know we're running a little short
no,
on time,
fine.
but if I could touch on one other topic that again cross-cuts both the FCPA and the False Claims Act, and that is, as I said before, you may have a case pending against you and not even know it. Either in the FCPA, the Department of Justice could be investigating you. You don't know that yet. You could have a False Claims Act claim made against you. And what we've seen in a number of recent scenarios are business transactions that occur where the acquiring company is essentially acquiring that liability and may not know that they're acquiring that liability, and the selling company is warranting that they don't have that liability because in good faith they don't believe that they do. And then after the deal goes down, the government or someone comes crashing in, and now you've got a big fight between the acquiring entity and the selling entity about who bears the liability, who has to pay for the attorney's fees, what are the indemnification provisions, are there stop-loss provisions. So even in the transactional area, and I see Mike Meany, one of the heads of our M&A group, is sitting right here smiling, this has got to be a part of your significant due diligence. You've got to, as best you can, drill down on that question and allocate that risk. Who's going to absorb that risk, and that may affect how you structure the transaction. We have a case right now that we're handling where the seller agreed to indemnify the buyer for what was then non-existent False Claims Act liability, and over the course of the last year, that person has been forced to indemnify back close to $1 million just in attorney's fees. We aren't even to the recovery phase yet. This is just the attorney's fees. So transactional people and business people, beware, that's an issue you need to put on your due diligence checklist.
Yeah. We promised you, or I should have promised you at the start, that we will end this by 1 o'clock today. We're very cognizant of your time. One thing which I've been asked to talk about, because I have a lot of experience with this, is STARK, anti-kickback. These are terms that for those in the world of healthcare sort of are middle names in a way, because we deal with this somewhat regularly. And it's not my intent to go through never was to go through here's what the anti-kickback law, here's what the STARK Act is. I worked in DC for some time with the Treasury Department, and Pete Stark was at a meeting, and this is after the Stark law came out, and he made the statement. He probably would deny it right now, but I would say this is being taped, so I'd feel very comfortable saying it. Had he had a chance to do it all over again, he would not have signed his name to that bill, because like so many statutes, particularly these, they have pretty safe background for it. We all agree. We all agree that doctors should not, I just say doctors, it could be any healthcare provider, should not get a kickback. You should not come to me. I should not be giving you extra money to send people to me who you normally would not send to me because I'm giving you, quote, a kickback. We all can agree on that. Now, how do you put that into statutory language and regulations and then apply it across the board? That's where the challenge comes in. Sometimes it's very simple. If you go online, you don't need us to tell you every single case. You go anti-kickback settlements, they're there. Some of them are pretty straightforward. Some of them are not, and there are settlements for other reasons other than someone being guilty of a crime. But we all can agree in the concept. Same thing with Stark. We don't want a doctor saying, okay, patient, come over here. I think that you need an MRI. Go down the street to, Dr. Jones's MRI, which happens to be my MRI place. And we don't want that in concept to be sending people there. We all agree on that. But now, if you look at the Stark law, the way it's written, it's very complicated, to say the very least. It keeps the healthcare lawyers in business. And I was speaking about, we were talking a little earlier about optics and about your relationships with the government and doing the due diligence. I won't give the names of the parties, but I represented a hospital, smaller hospital, being purchased by a larger hospital agreement. And under Stark law, one of the requirements is if you have any kind of deals with somebody, you have a contract, it has to be a written contract. You have doctors who are sharing in the facility. They're in there in office space. They're paying a fair market value at the time. Everyone knows each other. It's a sort of a smaller community. There was never an intent to defraud anybody. The hospital liked the physicians liked the hospital. They paid their rent regularly. In fact, the hospital liked these doctors so much they started picking up their garbage for them. They said, don't worry about it. We have our garbage people coming every Thursday. We'll just pick yours up as well. Just make sure the bags are out. Nothing big. I mean, if you try to speak to people in the profession, they would look at you with a big so what. This is just being courteous. Well, enter the Stark law. And this hospital now being purchased by a larger organization. We start doing due diligence on our hospital. We say, where are the physician contracts? Oh, we haven't had them in years. We don't need contracts because these are such good guys. They're not going to hurt us. And then we're out there and we were physically on site when the garbage trucks come up. And these doctors' staff is taking the garbage out. I didn't even think about it. The attorney I was working with said, how much did you pay for your garbage pickup? And they thought that we were just being pains in the necks about it, typical lawyers. It was amazing because we had a very good relationship with the U.S. Attorney's Office in that particular district. We agreed and the client agreed, let's self-disclose this. Because if you don't self-disclose, well, you're violating the law, even though I'm not trying to say self-disclose everything, but you should self-disclose everything, because then you don't risk being a false claims defendant. The government was very sympathetic to the hospital. Everything was on the up and up. It ended up being sold and everything was good, but there was still a payment of a lot of money by the hospital. And I give that, it's a small example of something where we don't even think about it. It doesn't have to be the multi-billion-dollar settlement with a drug company. This is a very good hospital, no issues of patient care, no nothing. The doctors, excellent physicians, people just trying to be nice to each other, and they still were in a trick bag. I think of that example regularly when I speak to people about the importance of having a compliance program. After that hospital, they were purchased, so they already had an existing compliance program. On the beginning end, you want to be able to show the government if something happens, because something's going to happen, I mean, whether it's big or small. You want to show them we had something in place, and not just a phony deal. We actually had attorneys, we had compliance folks set this up for us. We had regular training. I emphasize that for whether you're healthcare or any type of business, whether you deal with the government or not, you're going to want to have it showing that you have a culture of compliance. It gets in the way of a good time perhaps sometimes, but I highly recommend it. And so that if and when the government does come in, it's much easier for whoever your counsel is who's going to be dealing with the regulators. It could be HHS, it could be the FBI, it could be OSHA, it could be anybody. It could be state, local, federal, any level of government bureaucrat that comes into your world as you're trying to conduct business. We got to deal with these folks. And if you have something in place, you're in a much better position to deal with it. And if this is sort of beating a dead horse with a stick and so obvious to everybody, we wouldn't have these, 15 cases that I pulled out just recently, all within the last year of settlements with the government. It's something that I think needs to be reinforced with everyone on any level. And we are 12:56 on the clock, and I want to be mindful of your time. Anybody have any questions here in Cleveland? You can raise your hand. Sir.
Yeah, just a general question of the different types of cases that go on. You probably know about a lot of it. J.P. Morgan Chase was investigated, I would say, 6 months to a year ago. They were hiring relatives of a person that they wanted to do business with. And
I think it was a Chinese family member, right?
right. Yeah. Where did that case go? Was it found to be nothing, by the federal government?
I didn't follow up on it, but that's another great example of an FCPA violation, was hiring someone's relative that, frankly wasn't qualified. That's something of value.
Yeah.
At the time that was that was talked about in the press, they also said it was a common practice by large banks, investment bankers, et cetera, to do that.
And for the folks online, the question is, J.P. Morgan Chase was being investigated recently for having hired family members of people within J.P. Morgan Chase who were not qualified. I think it would be an argument if somebody was highly qualified for it. But these people, I think the allegations were not qualified. We don't have the follow-up on it, unfortunately. I'd love to tell you where it is.
I think that's a great question, though, because it begs the question of, as you pointed out, if this was a common practice and other banks are doing it, you would probably get people like us involved, and that would be a great point to self-disclose to try to stem any damage from occurring.
But your question your question raises another point, and since I was realizing the title here talked about business disruption as well. These investigations go on for long times, so it could be that the J.P. Morgan accusation came out in the media, and now the case has just gone back, it's under investigation, and it could drag on and on and on. And that's the other thing people don't realize. Compliance spending is like insurance, right? It's money you spend hoping you never have to use it, and you wonder, why am I spending this? Why am I paying for this when I'm never going to use it? Not only are these cases expensive to be involved with from just paying your attorneys, but it's disruptive to your business. You want to focus on making widgets or selling whatever you sell or providing the service that you sell. You don't want to be talking on a regular basis to regulatory lawyers, to the government. You don't want to be putting in either public financial disclosures or other lending documents that you have unlimited or open-ended liabilities out there, that you have litigation out there. So there's great just disruption to any good business operation if you have one of these things happen. And that's another reason why, as Jennifer was saying, if you have robust compliance programs in place, when the government comes knocking on your door, you can have the conversation Richard talked about with his hospital, right? Here's what happened, here's what we did about it, here's what we have in place. We really are a good company with a good culture of compliance, and you can bring the matter to a close a lot faster. It's very expensive and very disruptive to fight these things, and so the front-end investment in compliance really does come back to you.
True. Okay, well, we promised to conclude at 1 o'clock. And for those of you viewing our webcast, you can still email your questions and we will get back with you. For those of you here in Cleveland, you're welcome to stay later. We have extra food here for those. If you had one, you're invited to have two. Our team continues to track news and developments regarding white-collar matters in all sectors here. One of the ways we communicate this information is in our online community, the Business Advocate, at businessadvocate.mcdonaldhopkins.com. The URL is on the front page of your handout. By registering for this event, you are automatically a temporary member of the community. You received an email containing your login, temporary password, and additional information. Tune into the Business Advocate for follow-up and Q&A and a replay of today's event. We look forward to hearing your thoughts and perspectives about the topic discussed here. And we will email a survey requesting feedback on this particular business hour. And I strongly encourage you to respond to it because it helps us to know what's working out there, what you like, what we could do better. So we really appreciate your feedback.
And for anyone interested in FCPA issues, I have quite a few blog posts on FCPA, probably going back in the last 6 months, investigations, things like that. So if you didn't get enough FCPA, you can log on and get more.
Okay, well, thank you, everyone. Thank you.